All right, welcome back to another National PSI Real Estate Exam Prep. And today we're going to talk about leasehold and freehold estates. And more specifically, we're going to go over 5 questions with their explanations of to why they are the answer to help you pass your National Real Estate Exam. So, question number 1, when defining ownership estates, the term estate refers to a person's legal rights in the land or property. In terms of property possession, the term estate pertains to an individual's lawful entitlement or the collection of rights associated with land. These rights, contingent upon the specific estate category, encompasses privileges such as possession, transfer, encumbrances, and more. It's more important to note that estates are not inherently linked to the tangible size or monetary value of the land. Among the various types of estates, a fee simple estate stands out as the most elevated form, granting the holder the utmost or optimal rights over the land. Question number 2, a property owner conveys the ownership of his house to his mother and stipulates that on her death, ownership will revert to him. The interest the owner has in this property is a revisionary interest. While the mother is alive, the son possesses a revisionary interest. Upon the demise of the life tenant, the mother, the holder of the revisionary interest regains a fee simple absolute estate. The ownership or a qualified fee estate endures as long as the owner upholds the specific condition in the deed. Homestead designation provides safeguards for a principal property against specific creditors. A remainder interest is the rightful claim of a person designated as a remainderman, representing the individual, distinct from the estate's creator, to whom the life estate transfers upon the conclusion of the estate. Question number 3, the difference between a freehold and a leasehold estate is ownership versus possession. Freehold estate signifies ownership, whereas in a leasehold estate, the property owner grants possession to the tenant. Tenants may opt to cover all property expenses independently, share them with the owner, or have the owner bear the entire cost. Unlike freehold arrangements, leasehold agreements do not necessitate a right to purchase, and there is no provision for a right of survivorship. Question number 4, under the old common law, who could terminate an estate at will? The leaseor and the leasee. In adherence to conventional common law principles, either the landlord, the leaseor, or the tenant, the leasee, possess the authority to terminate an estate at will without restrictions. An estate at will constitutes a leasehold estate of possession. Please be aware that certain states currently either disallow this form of leasehold estate or establish specific notice prerequisites for its conclusion. The legal instrument known as a will outlines an individual's preference for asset distribution. A divisor is someone bequeathing real estate through a will, while the devisee is the individual set to inherit the real estate according to the terms of the will after the divisor's passing. And question number 5, which of these best describes a fee simple absolute estate? It is the maximum estate in land and lasts forever. Fee simple absolute estates endowed with the most extensive bundle of rights typically persist indefinitely as they are passed from one owner to another during title transfers. The imposition of a deed condition can result in the establishment of a fee simple defeasible or qualified estate. All right, these were 5 questions to help you pass your national PSI real estate exam. If this was helpful, give us a thumbs up and subscribe because we drop a new video weekly to help you pass your PSI National Real Estate Exam.